Hello everyone, welcome to another episode of ROCH Playbook for businesses. On today's episode, we are going to be discussing a very important topic that affects different businesses, whether small scale, medium scale, or large scale businesses, and that is data privacy and data protection. We're going to be dissecting key terms that affect data privacy, data protection. We're going to be looking at the legislation that covers these concepts. We're going to be looking at compliance to these legislations, and overall we'll give you business advice on how to comply to the provisions of the law on data privacy and data protection. So why don't we go right into this video? Now let's begin by dissecting these key terms that you need to know to understand what we are saying on today's episode. First, what is data? Now, the Nigerian Data Protection Act of 2023, which is the primary legislation regulating data protection in Nigeria, defines data or personal data as anything, information which a person can be identified by. So your name, your state of origin, your street address, your place of work, your gender, your blood type, your genotype, whatever is capable of identifying you as an individual, as an entity, as a corporation, is your personal data. Now, you who owns the data, or your clients or your customers who own these data, are referred to under the law as data subjects. There is a responsibility for certain individuals, which in this instance are businesses, to protect this data. These businesses are either recognized as data controllers, data processors, or data controllers of major importance. So who is a data processor? Or who is a data controller? Or who is a data controller of major importance? A data controller is a person who determines the purpose for which data is being processed. A data processor is a person who processes data on behalf of a data controller or another data processor. Why a data controller of major importance is a person that processes data based on the number of people within Nigeria, or has to be determined by the commission. The commission in this instance is the Nigerian Data Protection Commission, essentially the body in charge of regulating the Nigerian Data Protection Act, which is the primary legislation governing data protection in Nigeria. So if the commission can say you're processing 10,000 data within 6 months, you are now a data controller of major importance. It means there comes, additional responsibilities and requirements under the law for you. Let me give you a practical instance before we go into discussing what data processing is and what are the lawful bases of processing data. Now, let's assume that there is a business, a large-scale business called ROCH Meals that carries on the business of providing food, restaurant, leisure to people. ROCH Meals is a booming restaurant in 3 different cities in Nigeria. We're talking about Lagos, Abuja, Calabar, Port Harcourt, right? They're doing big things. ROCH Meals also have the ROCH Meals app available on Google Store. And so individuals, different people go into ROCH Meals, they purchase food, they pay with their credit cards, and they leave ROCH Meals to go and enjoy their meals. Some of them don't even go into the restaurants in these various cities. They sit in the comfort of their home. We're in that era. And they place the order online and use that application to get their food delivered to them. Now, ROCH Meals is the data controller because they determine what their customer data is being used for. Let us now move into the aspect where ROCH Meals now transfers that data to the dispatch rider who goes ahead to deliver this food to you. Now, imagine an instance where after you've ordered food from ROCH Meals, and ROCH Meals has said, okay, you'll receive your food in 45 minutes, a beautiful plate of jollof rice and chicken, or ishewu. You receive it in 45 minutes, and 40 minutes has gone past, and you receive a call from a dispatch rider that says, oh, hello, my name is Mr. John. I have your food here with me. I'm coming to number 10 Ekuke Street in Maitama, Abuja, to come and deliver this food to you. And one, you did not tell the dispatch rider your address, you did not tell the dispatch rider your name. But by virtue of him working on that ROCH Meal, he's now privy to that information. He's not using that information to get your order across to you. In an instance where days after this has happened, you start getting unsolicited messages or information from that dispatch rider or a totally different party third party that works with ROCH Mills or is associated with ROCH Mills, you can confidently sue them for breach of data. As data controllers and processors, they have a responsibility under the law to protect your data. It is a constitutionally guaranteed right, which is something most businesses do not understand. Section 37 of the 1999 Constitution of the Federal Republic of Nigeria clearly states it, that the privacy of citizens, telephone conversations, whatever, is guaranteed under the law, under the Constitution. And on the basis of the ground norm, which is the Constitution, we now have the Nigerian Data Protection Act of 2023, which outlines instances where you can process data, phases where you can even receive this data, the limitations to which you can use a data subject information. So it's not just all fun and games, it is actually a legal requirement on data processors and data controllers, as well as data controllers of major importance, to protect data. Now, let us move into the very critical part of our conversation. What is processing data? The Nigerian Data Protection Act 2023 has clearly stated that any operation carried out on data is processing data. So if you're collecting data, you are storing data, you are transferring data, you are saving data, you are destroying data, you are altering the data, you are processing that data. There has to be a lawful basis of processing data. This lawful basis is 1. Consent. It is very important that you receive consent from a data subject. In fact, the Act goes far to even tell you that as a data processor, as a data controller rather, you have a responsibility to establish that you had obtained consent of a data subject. The duty is on you. The burden of proof is now on you that, oh, before I use this data, I had obtained consent from the owner of this data. We have where processing that data is legally required under law. I mean, it is part of the duty of that establishment to process that data. I'll give you an instance. The Nigerian agency in charge of collating information, like INEC now, information for electoral purposes. You know, when you go to get your voter's card for election, you know, your name, your date of birth, your local government, your state of origin, even up to your address, your location is contained in their database. They have a lawful duty, a responsibility under law to collate this data, because that is what their agency is about. Immigration offices, government agencies that process data of individuals, there is a legal basis for that. So that is another instance where you can say this agency has a duty to process this data. However, do not forget that because you have a legal basis doesn't mean you now do whatever you want to do with the data. You still have a responsibility to protect that data. Another basis is where not processing that data contravenes public policy or interest of justice or the general public interest. The Act outlines different bases, but the most important one is, consent, which affects a lot of businesses, because you deal with consumers, you deal with customers who come to engage your services or to buy products from you. Now, how do you protect this data, or what does the law say about even going into this? Before we move on to the provisions for large-scale businesses, let's talk about the basics that everybody or every business must engage in. Consent. Now, there are 3 principles on which this is predicated. 1, there must be a lawful basis of you collecting this data. You don't just collect data because you want to store it and just use it for your personal use. No, there has to be a legitimate reason you're collecting this data. There has to be a limitation to what you say you're collecting this data from. If you say, this ROCH Mills that we're talking about, you say you're collecting data to do their orders and have their food delivered to them. You cannot now use this data for promotional videos, or use this data and transfer it or sell it to an outright third party simply because the data is in your possession. The law prohibits you from doing that. What the law requires a data processor or a data controller to do is specifically tell you what your data is. In fact, this is how the Act even says it. First, these data controllers have a responsibility to tell you the name of their business, the address. They also have a responsibility in the data privacy policy to tell you why they are collecting your data. The law gives data subjects certain rights. Rights to be informed that their data will be collected. Right to be informed what their data will be used for. The right to even lay complaints to the NDPC, like I said, the Nigerian Data Protection Commission, in the event that you collect their data and you have now contravened the provisions of your policy. You collected their data for promotional purposes, but now you're using it to send unsolicited messages that have nothing to do with your business. They also have the right to request that you delete their data, you erase it because they are no longer interested in the services that you offer. Let me inform you that there are now court-decided cases. There are decisions of court policies that have now been put in place to punish businesses for non-compliance to the provisions of the Nigerian Data Protection Act of 2023 and other data protection policies that have been put in place. So as a business, what should you do? What steps should you take to ensure that you're in compliance? Because guess what? If you contravene the provisions, the penalty, you can pay up to 2 million in fine. You can even be jailed. Your directors or the people behind your company can actually be prosecuted. So first, you need to have a data privacy policy as a business. Your policy outlines all that you require as a data controller or as a data processor from your data subject and what you intend to use their data for. Secondly, appoint a data protection officer. The data protection officer gives you information or advice on what you need to do to comply with the provisions of the law on data protection and data privacy. Thirdly, carry out annual data protection impact assessments. It's like an audit, like an annual audit that you carry out. You check your policies, you check global trends, you check trends within the Nigerian jurisprudence, whether your policy is still in line with the provisions of the law. In this way, you avoid penalty, you avoid being wrong on the wrong side of the law. And most importantly, if you're yet to register yourself when you're a data controller of major importance, the law provides that you should have done that within the first 6 months after the act or within the first 6 months of your business. So it is important that as a data controller, you quietly go to the NDPC and go and register yourself so that you avoid being on the wrong side of the law. Thank you very much for listening to me on this episode of ROCH Playbook for Businesses as we have discussed data protection, data privacy under the Nigerian laws. And until next time, please do not forget to tune in to ROCH Playbook for Businesses. If you require more information or detailed analysis of the Nigerian Data Protection Act, don't forget to check out our website www.rochattorneys.com because we have published works on this subject matter. And until next time, ladies and gentlemen, bye!